Hey guys, so I decided to do my discussion for this week on the case study about student records and breach of confidentiality. So a little background, Jamie Price, a teacher in an affluent high school in Mid-South, reviewed the educational records of one of her students and discovered some very confidential information that she shared with another teacher during their break in the teacher's lounge. Because the other teacher had not personally accessed the information, she felt comfortable sharing this information with another colleague. So the first question that I asked was, is there a risk in sharing confidential student information with a colleague? And I said, yeah, there's a definite risk. When Price decided to share that information with her colleague, school personnel should pretty much refrain from aimless chatter involving third parties regarding confidential information found on student records. So this could be viewed as gossip or careless talk among school personnel calculated to harm a student is not protected by a qualified privilege. And that's what Essex said on page 200. So Price, while Price had a legitimate educational interest for viewing her student's file, the other teacher did not have the same privilege. Price also shared the confidential information really nonchalantly, so there's a possibility that the other teacher could also then go and share the information and pass it on to another teacher as well. This talk and spreading of confidential information could potentially be seen as slander. So what legal options might the student exercise in this situation? Well, it really depends on how old the student is, whether or not he or she can represent himself or herself, and if not, the parents can get involved. So since there's no legitimate educational interest for the other teacher, the student has a few options that he can exercise or she can exercise. Since the confidential information was shared with another teacher, this could be viewed as slandered, and that's the oral defamation, which occurs when school personnel communicate sensitive and damaging information contained in student files to others who don't need to be informed about that information. It involves communications with a third party. So depending on the age of the student, the parents may also become involved. If the alleged claim is proven true, parents may bring charges against the school. So parents do have that right to file complaints with the U.S. Department of Education concerning violations and can seek relief in civil court if necessary. They may also, under certain circumstances or conditions, bring charges of defamation against school personnel and the school itself. What would Price's defense be if if she's challenged? So I feel that Price's only defense currently would be maybe she shared the information in good faith, which I don't think she really did, but good faith requires that a legitimate purpose be served by communicating the information. It's communicated for a legitimate purpose and without any intent or desire to damage the student. Like I said, I don't think that she wanted to damage or hurt the student, but the way that she shared the information could potentially do that. Price could have shared the information with her colleague in order to collaborate together in order to help the student in question. However, there are better ways to do it than just talk about it in a teacher lounge. Teachers, counselors, and administrators who have a legitimate educational interest in viewing records, they may do so, but there's a way to do it. You have to have a written form, and then that's permanently in the file to show specifically what files were reviewed and by who, and when they were reviewed. Unfortunately for Price, the way that the courts are probably going to rule this one are with the parents and the student. So I feel like if this was brought to the courts, they would rule in favor of the student and the parents. If Price was trying to communicate confidential information to another colleague, there are policies and procedures that first have to be completed. Price shared this information with a colleague in an area that could have been overheard by another person, even a student. If this information is heard by the wrong person, it could potentially ruin the student's school reputation or life in general, depending on how far it went out, even if it went out of school. Price committed slander by verbally sharing confidential information with her colleague. She also violated FERPA by not protecting the student's records. As far as advice I would give teachers when it came to confidential information. I would state unless there was a really good, legitimate educational reason to share confidential information, that it shouldn't be shared. If there is a need to share information, you need to take the proper steps in order to do so, so follow protocol. If confidential information needs to be shared, I think it should almost be done written, either over email with the person you need to share it with, or just it needs to be in a disclosed area where other people can't hear the conversation. School personnel should definitely receive training on handling sensitive and confidential information on students and students with disabilities.